Morning all, welcome to this webinar on what do judges want, tribunal judges want. I'm joined today by Daniel Penman, who is a barrister at KBW Chambers in Leeds. He is an employment law and litigation specialist. Morning, Daniel. Thanks for joining us.
Oh, I'll have to mute myself to say that. Good morning. You're very welcome.
Daniel's going to talk to us today, along with myself, as I say, about what do tribunal judges want, and we're each going to focus on a slightly different area of the tribunal process. Daniel's just put a slide up here, just a little bit about me for those that haven't really spoken to me before. I'm an employment law specialist at Haworths. I'm the senior employment law solicitor, and I've been doing employment law for 10 years now, both for employees and employers. So kind of a bit of both, which it always gives me a fairly interesting take on things, I think. We're going to show you some slides as we go along, and you can actually change the way you view the screen. So there should be a button that says view towards the top of your screen, and it will give you the option to see side-by-side view. Side-by-side view, you can choose either speaker or gallery. That way you'll be able to see both Dan and I, or just whoever's speaking, alongside the slides if you wish. So feel free to maneuver things as you like and view it whatever works best for you. Obviously, don't feel obliged to look at Dan and I. You can just look at the slides if that's preferable, and we won't know. So that's absolutely fine. We're going to look today at the tribunal process, the employment tribunal process, and some tips on what judges are looking for in that process, and some guidance on what to avoid. I'm going to look predominantly at the preparation side of things up to tribunal hearing, and Dan is going to focus on the tribunal hearing itself. We will take questions towards the end, and you'll see a Q&A button at the bottom of your screen. If you've got any questions, just bob them in that box and we will answer them towards the end. You can put them in that box at any time, whatever suits you. So on to the start of things, really. So the Employment Tribunal is part of Her Majesty's Courts and Tribunal Service. It is an official civil court. And the Employment Tribunal has jurisdiction for employment law claims, which includes discrimination claims relating to work. The employment tribunals were formed as a more informal forum for dealing with industrial disputes, and has different rules on who can bring claims compared to other courts. It is designed to be slightly less formal. And cases are managed and decided by an employment judge. An employment judge is someone who has a significant background in employment law generally, usually a barrister, a solicitor, or a legal academic. So they are specialist employment judges. As part of the management of a case, a tribunal judge will set a timetable for preparing the case for a hearing. And the deadlines that are set are specific court orders made by the judge that need to be complied with. And whilst it is a more informal setting than the civil court, it is still a formal court process. As a general overview, you're always trying to demonstrate to a judge that you've acted reasonably, professionally, fairly, and in accordance with the law. And this can be demonstrated through the actual evidence that you've presented, but also through your conduct in preparing the case for a hearing. You don't want to give the impression that you're being belligerent or obstructive or unreasonable in the way that you handle things. It can be difficult at times, because naturally you can feel quite defensive when you're on the receiving end of a claim. And it's human nature to put up some barriers when you're being accused of something you don't necessarily agree with. But if you can take that step back and help the tribunal by ensuring that the case is properly prepared for hearing with as little input from the tribunal as possible, it will generally work in your favour. That's not to say that you should just do everything or agree to everything that the other side asks of you, but equally, don't refuse to do things or refuse to agree to things without a good reason. I'm going to go through some of the key steps in preparing a case for hearing. There can be many other things that might happen in a case to get it ready, depending on the type of claim that's being brought. But the things I'm going to go through are stages that happen in virtually every case, pretty much no matter what type of claim you bring. And every claim starts with a form called the ET1. So prior to a claim being started in the tribunal, there is a requirement for the claim to be referred to ACAS for early conciliation, but I don't propose to say much about that, except that it's designed to try and reach an early settlement in a case without it going to hearing. It can have mixed success, but once a certificate's been issued by ACAS confirming it was referred to them, the claim can then proceed to the tribunal stage. The claim being made is instigated by lodging the ET1 form. That's just the name of the claim form that's used by the tribunal. And it's a prescribed form that asks for certain mandatory information so that the tribunal have the minimum it needs to essentially understand what claim is being put forward. If the mandatory information isn't received on the form, the tribunal can refuse to accept the claim and will normally refer it back to the claimant to resolve any issues on that form. There's often a bit of a misconception that when the tribunal is sent a claim, they'll immediately assess whether the claim has any merit before they actually proceed to take any further steps. But actually, the tribunal generally will only check that basic procedural information's been dealt with, so that all the right boxes are ticked on the form, that there's a code for ACAS, that sort of thing. They won't normally actually assess any merits at the point that the claim's issued. So when you receive a form, receive a claim through against you, it won't have been looked at particularly closely at that point. The tribunal will send a copy of the claim form to the respondent. The respondent is the company or the person that the claim is made against. And the purpose of that is to then give you the opportunity to respond to it. It will have a deadline in the information you're sent. And that deadline is the point that you have to make sure your defence is received by the tribunal if you want to defend the claim. So when you receive all this information from the tribunal, you will be asked to respond on something called an ET3. The ET3, again, is just the formal official name of the form you have to fill in to defend a claim, or even to tell the tribunal you don't want to defend a claim, which is an option. And that's how you will respond, and you'll be given a deadline for that. When you do receive a claim from the tribunal, the best thing I can say is act quickly. The tribunal will only allow initially 28 days for a defence to be sent to the tribunal, back to them. So you only have sort of a little below a month to actually get your full defence in. Send it to your legal advisors as soon as you can. The more time that you and they have, the better. And the more you can concentrate on how to put that defence together, the better that defence will be. There's a lot of ground to cover to properly understand and present a case. And if it's rushed, you can miss key points right at the outset, which can then have an impact on how the claim goes from then on. If you miss key parts of your defence, there's always a risk that you may not have the opportunity to actually present those later down the line. So definitely try and act as quickly as possible to get to the bottom of what the claim is and start putting your defence together. This may seem like a slightly odd point to make, but make sure you tell your advisor everything, whether you think it shows you in a good light or not. As an advisor, there's nothing worse than finding out about something partway through the process from disclosure or from witness evidence that you didn't know about before, particularly if that something potentially is problematic for the claim. It's much better to tackle problem areas head on and have time to consider the best tactical way of dealing with any weaker areas in the case. Also, if issues aren't addressed in the preparation for the hearing, there's a good chance that they won't come across as they should at a hearing. So even if you feel that some of the things that happened are not particularly beneficial to the claim, make sure you tell your advisor about them, because they will be best placed to work out how to approach dealing with those. Try and focus on the legal issues. The purpose of the defence is to set out the response to the legal claims that have been made against you. At the point the defence is submitted, the tribunal don't want to know all the factual details. That can come later. That's something for witness statements further down the line. What they want to know early in the process is in general, how do you intend to defend the legal matters that are in issue? It can be hard to leave things out, and I'm always reminded of the quote from Mark Twain. I apologise for such a long letter. I didn't have time to write a short one. And that very much comes to mind when doing a defence for me, because it can be difficult to leave some things out. The defence ultimately helps to create a structure for the rest of the matter, and to create focus on the key issues that will help avoid unnecessary and irrelevant matters becoming the focus later. So it really is a focused document on legal matters, not the factual matters. But I think the most important thing when it comes to defending the claim is meet the deadline. If you don't meet the deadline, the tribunal has the power to prevent further participation, or at least limit further participation in any hearing. It could mean that you don't have the opportunity to put forward a defence or challenge the claims being made in any great detail. You don't want to be in that position. If there's a good reason why you're not going to be able to meet a deadline, you're much better to tell the tribunal in advance and request more time. They don't have to give it to you, but it's best to do that than simply miss the deadline and try and obtain an extension after the fact. So the deadline is absolutely key when it comes to defence documents. So what happens then after you've got your defence in? You've got a claim in the tribunal that's come from an employee, you've put your defence in, and then we start to look at further management of the case from there. Again, the tribunal won't carry out any detailed assessment of the merits as such. They will look at the claim and the defence and see whether there's any clear issues with either, but for the most part, they're not going to make a decision about the case on the documents alone. So what they do to then get things to a stage where they can make a decision is ask for various steps to happen to make sure the tribunal has the information they need and each side has the information they need to deal with the case at a hearing. So disclosure is something that is always required. Disclosure simply means providing all the documents that are relevant to the other side. So both sides have to provide the other with all the documents that are relevant to the case. The law requires that the parties inform the other side of all the documents they have that are relevant. And that's often done by a list of what people hold. And it includes documents that are both helpful to the case and those that are detrimental to your case. And it is a legal requirement that you do look for all relevant documents and not just those that support your position. The purpose of it is to ensure that both sides see copies of all relevant documents in advance, so that the case can be fully prepared and the evidence that everybody intends to refer to is known by both sides ahead of time. There is a requirement to carry out a reasonable search for documents, which includes searching email accounts. It includes looking for any other electronic files that are relevant to the case, as well as sort of hard copy paper documents. In some instances, that could involve a search for email servers, depending on how difficult that is to do, but it is a reasonable search for documents. The best advice I can really give when it comes to disclosure is be prepared and be organised. Given that disclosure will happen in every case, you must be prepared to actually comply with that requirement for disclosure, which means trying to be organised and begin collating relevant information as early as possible. It is much harder to do a reasonable and proper search and find information when under pressure of time. So given that it always will arise, then you can make sure that information is collated and saved in a sensible way. And I guess the addition to that is the general point that keep notes of things that happen when you are managing staff. So when you have meetings, make sure you are keeping a record of what's discussed in those meetings, because you never know when you might need them. Make sure, again, that you meet the deadline for disclosure. It is a court order, ultimately. And the tribunal does not want to be bothered by emails from the parties complaining that the other side hasn't complied with orders or hasn't provided evidence unless it's really important. Tribunals will generally expect the parties to communicate between themselves to prepare a case. They don't really want to get too involved other than setting deadlines and saying what needs to be done. And the more they have to get involved, the more irritated they generally are. And it doesn't really put the party that's creating the difficulty in a particularly good light. You're always better to try and get the tribunal on side and give them as little work as possible, ultimately. There is an expectation that the parties will act professionally to get the case ready for hearing. And that, again, can be difficult if you're not legally represented, because obviously you're trying to prepare a case with someone who is ultimately accusing you of something that you're not happy with. But again, try and take that step back and approach it as professionally as you can. It will work in your favour ultimately. One thing that, and this is going to seem like a really minor point, but one thing that always causes me some frustration when I'm preparing disclosure is being provided with things like copy and pasted emails rather than the actual email itself, whether that's a printout or electronic. Copying and pasting into a Word file, for example, is just incredibly difficult to deal with. And also, with it not being the original document, it always raises questions about whether anything has been changed in that email when it's been copied over or anything like that. And you definitely want to avoid those sorts of questions. Also, if you have an email string that contains loads of different entries on different dates with people responding here, there and everywhere, it's okay to just provide one complete copy of the whole email string that has all those entries in it. You don't have to provide the email at every stage. All you do when you do that is provide create a huge amount of duplication. And it takes quite a long time to trawl through those emails and work out which ones actually need to be disclosed, which are duplications, and sort of it's a lot of time spent that doesn't need to be spent, which actually could have an impact on your legal costs. And also you don't want to be asking the judge to be looking through multiple emails with the same information in. There's not a huge amount else to say about disclosure, really, because it is as simple as providing copies of documents. And once disclosure's taken place, the next step is the bundle. So a bundle it is simply a folder that contains all the relevant documents that are going to be referred to at the hearing. So the tribunal will work from one complete file of papers, the bundle, and it should contain all the documents from both sides that will be referred to at the hearing. So they only really want to see documents that they'll be asked to look at and take into consideration. They don't want to see absolutely everything if it isn't something that they're going to be asked to look at. So if, for example, you want them to consider something in your disciplinary procedure, then don't provide the full staff handbook in the bundle that the disciplinary procedure is in. It's not necessary. It just creates a huge number of documents that nobody's going to look at. Always focus on the particular document that you want to refer the judge to at the hearing, because the bundles otherwise can get really out of hand, and it's often quite difficult at a hearing to chop and change between different documents and find pages in that bundle, because within that file everything is page numbered, and as you go along you'll be referring back to various pages. So the fewer documents that are in there, the better, really, as long as you're covering everything. This is a bit different to disclosure, because obviously disclosure you provide everything, whereas the bundle you have to take into a bit more careful consideration whether or not it's something you actually want to bring to the attention of the tribunal. So leave it out if you're not going to. Do your best to try and agree the contents of the bundle with the other side. Again, the last thing the tribunal want to do is deal with a preliminary question at the start of a hearing about whether or not certain documents should or shouldn't be in the bundle, or be presented with multiple folders of different documents. What they need is just one folder with everything in it, and agreed by the parties. They have limited time to deal with all matters. A hearing is set effectively for the minimum amount of time that's needed to deal with all of the issues. So when you start having to deal with administrative or preliminary questions, you start eating into that time. That could mean that in the end you don't get the outcome on the day, or you don't manage to get finished. Sometimes it is necessary to have preliminary issues, of course it is, but as far as possible, try and deal with the ones that can be dealt with in advance, rather than leaving it. And I guess this sort of feeds back into that point about not refusing to do things for the sake of it. If someone's asking you to put something in the bundle and you don't really see how it's relevant, by all means ask, but ultimately if they're going to refer to it, it's got to go in. So try not to be too obstructive if you're actually responsible for putting that bundle together. The bundle is used at the hearing, as I say, and it's got page numbers in it, and it is cross-referenced in witness statements, which is the next step that we'll have a look at. And I know Daniel's going to talk about witness statements as well, and we're going to do our best not to duplicate information here and come at it from a different angle. And witness statements are really the point that I referred to before, where you get the opportunity to talk about all the facts, all the actual incidents and issues that arose that have led to the legal claim. Witness statements are incredibly important, and I'll try and give you a bit of information about statements from a preparation perspective rather than a hearing perspective, because I know Daniel's going to cover more about witness statements and the hearing. A witness statement is a written record of all the things that an individual witness wants to say to the judge at a hearing. There must be a statement for all the witnesses that any party actually wants to call. And when I say call, All I mean is for any witnesses that are going to go along to the hearing and actually tell the judge and the tribunal something about what happened. So you have to consider carefully who you want as a witness initially, and call those people who can give direct evidence and information on the key issues in the case. You don't want to turn up with an army of people that don't actually add an awful lot to the claim. You want to try and focus on the key legal issues, the key information the tribunal needs to go, and really from the perspective of someone who had direct involvement. So try and avoid things like character witnesses or witnesses that are going to talk about something that's very much on the periphery. Witness evidence really does take time at the tribunal, and the more witnesses you have, the longer a hearing will take. A judge doesn't want to sit through 2 hours of evidence from a witness that really has nothing to say about the actual legal issues that the judge needs to decide. Because ultimately, a judge will approach the matter as a series of legal questions, because each legal claim has a number of specific points or questions that a judge has to answer in order to decide whether or not you win or lose. So any evidence really is very much focused on those legal questions. The witness statement contains the evidence of the individual and not of anyone else. So it's not the evidence of your legal representative, it's the evidence of the individual speaking. So the witness does need to understand what is being said and why, if they're going to properly explain themselves to the judge and the other side. If it's written by someone else in someone else's language, it can be quite difficult to follow when it comes to giving evidence at a hearing. And it can lead to question, when a witness is asked questions, it can lead them to giving different information, to coming across as if they don't really understand what it was that they were trying to say in their statement. So when I prepare statements, I tend to create a chronology of the factual matters that I'm already aware of from having obviously dealt with the claim up to that point. And then ask the witness a number of questions relating to things like how they felt, what they thought, how they reached certain conclusions, that kind of thing. Because the factual chronology is relatively straightforward, but what the judge wants to know is the real detail of the decisions and things that arose from the person that was involved. They don't really want to know anything from me other than legal stuff. So the witness statement is very much the individual's document and not the legal advisor's. When putting together the statement, as I say, I tend to approach it chronologically because it is important that the statement is set out in a logical way so that the judge can follow the story of what happened, really. Chronologically, as I say, works very well, but there might be occasions where there are more sensible ways to set it out, depending on the type of claim. But ultimately, we have to make sure that it's logical and makes sense. The information in it, in a witness statement, is factual evidence. So it's where you set out all the specific incidents and actions that happened, but whilst it's focused on, whilst it contains the factual information, that factual information should still be focused on the legal questions that have to be asked. So don't include absolutely everything, every thought, every issue, if it's not actually relevant to the claim that's being made. It might sometimes feel important to make a comment about everything that's been raised, every problem or every issue that arose during employment, but that often only serves to dilute the evidence on the key issues, and it can get lost amongst irrelevant information. So again, witness statements need to remain as focused as possible. It's also important to try and keep emotions in check and try and tone down the emotive language in statements. That's not to say that the evidence should be absent of emotion at all. Emotion definitely has its place in explaining what happened, and what was going on at the time, but try and keep it as focused as possible and avoid comments that can simply be seen as mudslinging ultimately, so that you remain on that professional footing with the judge. And normally when you prepare a witness statement, you don't know what the other side are going to say, because witness statements are normally what we call exchanged simultaneously. So that just means that we would provide copies of our witness statements to the other side at the same time as they provide copies of their witness statements to us. So everybody gets to see what everyone's going to say in advance. But of course, you don't know until you receive it what that witness is going to say. However, we do try and predict key issues in the case when we're doing statements to make sure that we address them as best we can in advance. If when you're working through your statement, you think there are things that are likely to be brought up, or things that you think are likely to kind of be referenced, then try and anticipate them, comment on them in the statement. And we try to take the view that if it's not in the statement, the judge won't find out about it. So if you think a particular point is going to be raised by a witness or by the other side, try and get into the statement what their response to that, what your response to that is going to be, so that it can actually be put before the tribunal for a decision to be made. It can be a lot harder to answer a question at a hearing when under fairly significant pressure than it is to answer it in writing with time to consider how you want to phrase it. And you might still get asked about it at a hearing, but you then have an anchor point from your statement, kind of a reference to be able to help you explain your thoughts, because you can obviously look at your statement as you go along. And lastly, on the preparation side, and particularly witness statements, avoid hearsay. So hearsay is basically just giving evidence on something that someone else has said or done that you didn't actually witness firsthand. The evidence in a statement should be that firsthand, direct evidence of what you saw, what you heard, what you did, what you felt. And an employment judge is likely to get frustrated with a witness when they start to give evidence about something that they actually don't really know about. They would much rather hear direct from the person that was involved. As I say, that's all I'm going to say about preparation. And once all the preparation is done, ultimately the next step is the hearing. I normally try and instruct a barrister, such as Daniel, to conduct the hearing itself. Daniel has a different skill set to me and is far better trained to manage a hearing than I am. It's very much a barrister's area of expertise. So with that in mind, I'm going to pass you over to Daniel, who'll look more closely at tribunal hearings and things like that with you.
Hello, everyone. Good morning. I'm going to stop scowling at you down the camera now and hopefully give you a little bit of insight into what goes on at a tribunal hearing. First of all, a little bit about me. As Sarah said, I'm a barrister. I'm a specialist in dealing with hearings and particularly employment tribunal hearings. I've recently been dealing with quite a lot of disability discrimination cases. So I'm well versed in dealing with these sorts of things. What I'm going to talk to you about today is going to be three things. First of all, the process that we go through at a hearing. Secondly, I'm going to give you some guidance on giving evidence and helping employees and others give evidence. And then finally, a few tips on how to get the tribunal on side and making sure, perhaps more importantly, that you don't push them away from your position. So starting with the process, I'm going to start where Sarah left off, just reinforce a few things about witness statements and say a few different things from a different angle, as Sarah says. Witness statements, in my view, are the most important part of the tribunal process, because everything that you want to say, everything that you want to rely on needs to be in evidence. And if it's not in a witness statement, then it's not in evidence. So if you have something that you think you want to rely on and it's not in there, then you're going to run into trouble further down the line at the employment tribunal when you have this vitally important thing that you want to say and you say it in response to a question And the immediate question you're going to get back is, well, that's very important. Why isn't it in your witness statement? And it immediately undercuts the credibility of that important thing that you want to rely on. So it's very, very important that everything that's relevant goes in those statements and goes in there in sufficient detail. As Sarah said, it's your document, it's not your lawyer's document. That means you can't get it from your solicitors and say, well, that looks fine to me, tick, sign it, send it back. There needs to be some real thought and some real time put into preparing those witness statements to make sure that they say things, not just say all the things that witness needs to say, but say them in the way that that witness would say it. Because again, it can be little things, it can be nuances of wording that people pick up on. And these things can really come back to bite you when it gets to the tribunal. If something's been said in a way that the lawyers think is appropriate, and then the witness says them in a completely different way and it changes the meaning, that can be a real problem, particularly for respondents. You're telling the tribunal your side of the story, as Sarah said. You're setting out the facts, not the law. The whole reason that you're paying Sarah, that you're paying someone like me to go to a tribunal for you, is to argue the law. You do not need to mount an argument in your witness statement. What you need to do is tell the tribunal about what happened to enable Sarah, to enable me to make that argument and to enable the judge to assess whether that argument is the right one. Sarah mentioned the key people, the people who need to actually be giving witness statements. And I just wanted to say a little bit about that because it's tripped people up in the past. Those people are the people who've made the decisions. Now, these may not be immediately obvious, especially in discrimination cases. And you should talk to Sarah nice and early to make sure that you're getting the right people to give evidence. So for unfair dismissal, the decision maker is the person who makes the decision to dismiss. Managers will be important, but you can't just rely on a manager who says they were rubbish without having the decision maker there who's agreed that they're rubbish and made the decision to dismiss. Similarly, for discrimination, it's the person who has made the allegedly discriminatory decision. And that can be someone who's quite distant from the employee in question. It can be someone who's sat making a decision about auxiliary aids in a reasonable adjustments claim. So if they're saying someone can't have a particular chair, for example, those are the key people that you need to make sure you have evidence from and direct evidence from. You can't just rely on a manager, as Sarah says, saying, well, I was told by Vicky, who works in HR, that we couldn't have this. No, she's not here today to tell us why. That won't cut it. So you've got to make sure that you've got those key decision makers there making witness statements. Other than that, I'm not going to go over again what Sarah's said. I endorse absolutely everything she's said. I do want to particularly endorse what she said about the bundle. There is nothing worse as a barrister preparing for a hearing than receiving a 1,500 page bundle to discover that 500 pages of it are irrelevant policies and another 500 are duplicated email chains. It is really well worth putting the effort in to make sure that the bundle contains the relevant documentation, not just because it keeps your barrister happy, but it keeps the tribunal happy, because they will be no happier than I will to receive that bundle full of documents that they just don't need to read. So that deals with just about everything in relation to witness statements. What happens before a hearing, then, before you actually get to the tribunal hearing? Case has been prepared, a hearing's been listed, so what needs to happen? Well, your witnesses need to have read their witness statements. That might sound really, really basic, but the number of times I've turned up to a hearing to find that a witness tells me, oh, my witness statement, yeah, I did it months ago, I haven't read it since. And so you have to occupy half an hour, 45 minutes of time that you could usefully be spending clarifying issues with your witness, letting them read through what can be a very lengthy statement. And ideally, they should have read it more than once. It's like revision. It's like an exam. And people need to know what's in those statements because they are going to have to answer questions about them. They also need to be familiar with the bundle, particularly the key decision makers, because they're going to be asked questions about the documents in the bundle. They should, at the very least, have read the documents that they refer to in their witness statement. but ideally any document that relates to them that's in the bundle, they should have the opportunity to read. I know it's a complete waste of trees, but getting people copies of the bundle so that they have the chance to go through them and read them, there is just no substitute for it, I'm afraid. If you've got people who are sufficiently tech savvy, who've got the equipment to deal with it digitally, brilliant, email them a digital copy. But otherwise, get it printed, get it sent to them, and get them to read it, because that really is going to add to your chances of success when it comes to a tribunal. It may well be that either you want to have a conference or the lawyer who's going to represent you wants to have a conference prior to the hearing. You want to make that as effective as possible. So again, this is an opportunity for the witnesses to have made sure they've read their statements, to make sure all the documents are in the bundle, and the witnesses are going to be asked questions to clarify any issues that might arise and make sure there's no fundamental gaps in the evidence that need to be filled before the hearing. So that means making sure, again, the bundle's prepared, they're ready to go, they've read the bundle and they've read the statements. And that means you'll be able to have a nice, effective conference in a short amount of time, because all that happens if you have witnesses who turn up unprepared, if all the documents aren't there, is it's going to take longer and ultimately it's going to cost more. So really, by preparing in advance for these things, making sure they're well prepared, what you end up doing is saving money. And that's the practical impact of that. One thing that you may now have to prepare for, which if I'd been giving this talk 2 years ago, I wouldn't even have mentioned, is the possibility of a video hearing, of doing a court hearing like this, with me sat in my attic, Sarah sat in hers, and you sat in your office or wherever else. If you're going to have witnesses giving evidence like that, they will all need copies of the documentation. They should already have them if you've followed the advice that I've given earlier, but if they don't, they've all got to have a good copy of the bundle of all of the witness statements so that they can refer to them. They're going to need a quiet, neutral space to give evidence from where they won't be disturbed. Now, actually, if I was doing a hearing, where I am is not a good example of a quiet, neutral space, because I've got distractions going on in the background. I've got a light that people might be looking at. I've got a map. Ideally, what you want is a nice blank white wall. So that's what you need in order to make sure that your witnesses are giving the most effective evidence possible. The other thing is they need a stable internet connection. I recently did a case in Nottingham where on the first day, my client, who was a police officer, her internet connection simply wasn't good enough. And so you couldn't hear her. She couldn't effectively participate in the hearing. So we adjourned off to the next day. The next day came around and someone else had an issue with their internet connection. And so what should have been a 5-day hearing, the first 2 days were completely ineffective. And as a result, it had to be adjourned off for several months to come back and start all over again. That costs an enormous amount of money, and it wastes an enormous amount of time, including the time of you and your employees and your witnesses. So it really is worth making sure that if you are going to have a hearing that's conducted by video, that it can be conducted effectively. The other thing to consider when you're thinking about communication at a video hearing is how you're going to talk to your lawyer. Because if I'm sat in a different room to all of the witnesses, what would happen in a tribunal setting, that they tap me on the shoulder or whisper to me from where they're sat behind me, can't happen. I found WhatsApp to be a very useful way of dealing with it, but it's just something you need to consider, how that communication is going to be managed in a video hearing to make sure that it can be, again, as effective as possible. Then we have the day of the hearing itself. So who's going to be there? Well, assuming that it is a hearing in person, you're going to have the lawyers, you're going to have the parties, you're going to have the tribunal. In theory, members of the public and the press are allowed to come to employment tribunal hearings. In practice, they don't tend to turn up unless it is, for example, the Uber case that you've probably heard about. People, unfortunately, simply aren't interested in watching other people's employment tribunal disputes. Once you get there, the first thing that normally happens is nothing at all. it is generally speaking usual for the tribunal to call everyone in at 10 o'clock and say, thank you very much, we've got the bundles, we've got the witness statements, please tell us what we should read, now go away until 2 o'clock or until tomorrow or until Thursday, depending on the amount of documentation that there is in the case for them to read. So you should be prepared for that, and the witnesses should be aware, because it's a very stressful situation turning up to a tribunal, and you wouldn't want to be a witness turning up thinking, oh, I've psyched myself up to give evidence, I'm ready to go, and then suddenly nothing happens. So it's worth making sure that people know about the process, know what's going to happen before they turn up. Once the tribunal have read what they need to read, they will then hear some evidence. The order in which they hear that evidence depends on the type of case. So in unfair dismissal cases, the respondent's witnesses normally give evidence first. That's because it's the respondent's job to prove that there's a potentially fair reason for dismissing the particular claimant. In discrimination cases, the claimant's witnesses will normally give evidence first, because it's for the claimant to prove that there was some potentially discriminatory conduct. And I'll tell you a little bit more about actually giving evidence very shortly. Once the evidence has been heard, you'll have some closing submissions. That's just the lawyers arguing over who's right. This can take some time. A lot of it will now these days be in writing, and it can be quite technical. So it's not something, generally speaking, I would advise that witnesses spend too much time thinking about. The tribunal will then consider their decision and give judgment. This can be read out on the day, or it can be reserved and sent out to the parties in writing. And that will depend on how long it takes, how long is allowed for the hearing, and so forth. So that takes you through, very briefly, a thumbnail sketch of how a tribunal hearing will run. So now the important bit, giving evidence. So first of all, you give what's called evidence in chief. This is the evidence of your witnesses on your behalf. Most of the time, this will be extremely short, because what will happen is you'll be asked to swear an oath, either on a holy book or to give an affirmation, which is the non-religious version. I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. And then you'll be asked, have you read your statement? Is it true? That's it. That is the whole of the evidence that you will give live at a tribunal, unless there are some really exceptional circumstances, such as a really glaring hole in the evidence that needs filling, and the judge will let you fill it, because it's not guaranteed that a judge will let you fill it if you haven't done your due diligence, if you haven't done your witness statements properly at step one. Or if there's something else that's come up in the period of time between the statement being made and the hearing happening. That will also be something you'd be allowed to add. But generally speaking, that's it. And you then move straight into being cross-examined, which is the bit that most people are most worried about. And this is what takes the time. In some cases, really serious cases, people can be cross-examined over multiple days. Even if it's less than that, and even if you're well prepared, it can be a very difficult, stressful experience. So what I'm going to try and do is give you some tools to help make it easy, either for you or for your employees. What will happen is you'll be asked a series of questions by the lawyer for the claimant. They'll usually take the witness to documents in the bundle, and there will be things suggested to that witness for them to agree or disagree with. There are some key points that I need to run through as far as giving effective cross-examination evidence is concerned. First of all, listening to the question. It sounds, again, very, very basic, but when you're under pressure, when you're feeling stressed by giving evidence, you can often be so focused on getting your point across, on saying what you want to say, that you forget you're supposed to be engaged in a two-way conversation. And if you don't listen to the question, then you won't be able to do number two, which is making sure that you understand the question. And again, that sounds really simple, but I've seen witnesses over and over again who don't wait until the question is finished asking the question to start answering it. Most witnesses, in my experience, once they've been asked a question, will answer without any pause at all, between the end of the question and their answer. You need to give yourself a moment just to assemble your thoughts before answering a question. And if you don't understand, then say so. Now, obviously, there's a happy medium between answering immediately and taking 10 seconds to stroke your chin and work out what the best possible answer you could give is. And you need to find that happy medium, but a natural pause between the end of a question and an answer really won't harm the quality of our evidence at all. In fact, it will improve it. Next point, answer the question that you're asked. Again, witnesses who are really focused on getting their point across often start arguing with the person who's asking them the question, explaining to them, well, your question's wrong because actually the real issue is this. And I'm going to start arguing the case now as part of my evidence. It's not convincing. I'm sure all of us will have seen people on television, usually politicians, who get asked a direct question, and instead of answering the question they've been asked, they start talking about something else. They start talking about what they want to talk about. And everyone watching that thinks, I don't believe a word they're saying. And exactly the same thing will happen if you do that in a tribunal. So just don't do it. Just answer the question, regardless of whether you think it makes you look bad or not. It comes back to what Sarah was saying about making sure that all of the relevant evidence is there, making sure that you deal head on with things that aren't going to make you look good. Because the more you try to hide it, the more it looks suspicious when it eventually comes out, and it will. This ties into answering the question directly. The best answers to questions start with yes, no, I don't know. You can follow that up with an explanation, but you should always start by making sure that you've answered the question. Answer truthfully. This shouldn't need to be said, particularly when you've given an evidence to tell the truth. But it's often very tempting for witnesses to embellish answers, to omit things that make them look bad, to tell half-truths, and all of those things create their own problems. It will all come out eventually. And the best witness that I can hope for as a barrister is a witness who at the end of the case, I can say to the judge, well, look, Judge, you can believe everything this witness has said. They were transparently honest. They were realistic about what they had to accept. They were open when they'd made mistakes. That is a witness that you can trust and you can rely upon every word that's come out of their mouth. That's what I want to be able to do at the end of the case, rather than having to defend the integrity of my witnesses because one of them said something that, well, was a bit dubious or turned out to be wrong and were trying to make themselves or their employer look better. Final point, which hasn't made its way onto the slide because it occurred to me as Sarah was talking. A lot of the time, and this goes into witness statements as well as to giving evidence, people are asked about what they did. And what they say is, well, I would have done this. And that's not good evidence as far as I'm concerned, because it's not evidence about what that witness remembers doing. It's evidence about what they think they probably would have done because it's what they always do. And this is something that time and time again, I've seen tribunals pick up on and come back to and say, well, this witness doesn't remember what they actually did. All they can say is they would have done this because it's what they normally do. The claimant's given evidence to say they didn't do that, and they specifically remember that they did this instead. So I find in favour of the claimant because their evidence is better. So you need to make sure that witnesses understand it's important they remember the exact incident. If they don't, if they genuinely don't remember, and the best they can do is to say, well, I would have done this, well, fair enough. And that's the best evidence they can give. But if possible, the evidence needs to be, I remember this is what happened. So that's cross-examination. Moves us on to questions from the tribunal. All the same considerations apply when you're being asked questions by the tribunal. You really do want to be as open as possible, though. These are the people you're trying to keep on your side. So when they ask you a question, it is even more important that it is answered and answered fully than it is in cross-examination. Because if you start trying to avoid questions from the tribunal, it's only going to irritate them. And ultimately, whilst their irritation shouldn't colour their judgment, we thought this person was being evasive, absolutely will. The other thing is to think about why you're being asked questions by the tribunal. They clearly think there's something important that hasn't come up in the evidence so far. So try to give them what they're looking for. That's not the same, crucially, as telling them what you think they want to hear. They want an answer to a question, and you need to give them the truthful answer to that question if you can, not give them the evidence that is going to make you look better. It comes back again to this point about making sure the evidence is complete and it's truthful. And that's it as far as giving evidence is concerned. It really isn't difficult. The real takeaways are to make sure that you're answering questions and answering them truthfully. If you do that, you really can't go very far wrong. And once all the evidence is given, once judgment has occurred, what happens next? Well, you may have a reserved judgment, as I've referred to. That can take weeks if it happens. You ideally want to try and avoid that happening. Making sure that you've got the hearing listed for long enough that the hearing's going to be effective, because otherwise it just delays matters considerably. If you win, well done, you've won. Unless the claimant appeals or does anything else, that's that. If you lose, you'll have to comply with any order the tribunal makes for remedy, so compensation or reinstatement or anything of that nature. If you disagree with the tribunal's decision, you can ask for the decision to be reconsidered within 14 days. That's the same tribunal reconsidering the same evidence. So it's only worth doing if you think there's something that the tribunal has fundamentally misunderstood. You can also appeal, but appeals restricted to legal issues. And you can only appeal the tribunal's decisions on the facts if it's so perverse that no reasonable tribunal could have reached that decision. So, for example, if you have a situation where a tribunal finds that a particular person did something, and there is no evidence at all, not from the claimant, not from any of your witnesses, to say that person did that thing. That would be the sort of thing where you could go to the Employment Appeal Tribunal and say that decision's perverse. There is no evidence at all to support that. Anything less than that on the facts is within the discretion of the tribunal, and the Employment Appeal Tribunal are just going to say, sorry, we're not to interfere with those. That's what the law says. You might also end up with an issue about costs. Costs, of course, in civil cases are absolutely the norm. In the Employment Tribunal, not so much, because as Sarah said at the outset, this is supposed to be an informal venue for the resolution of disputes. The idea initially was there weren't supposed to be any lawyers involved at all, but we can see how well that's gone. In order to get costs in the Employment Tribunal, what you have to demonstrate is that the other party has behaved unreasonably, i.e. in a way that permits of no reasonable explanation. This is worse than just losing, and it almost never happens. So unless you've got someone who's behaved in a really vile way in the conduct of the proceedings, or has brought a case that just never made any sense in the first place, you're not getting your costs. Similarly, unless you behave in a really vile way in the conduct of the proceedings, or try and defend it on a basis that is completely nonsensical, the claimant isn't going to get their costs either. So then, the bit that I suspect everyone's really looking forward to, how do you win at an employment tribunal? How do you get the tribunal on side? Well, I unfortunately am a lawyer and not a magician. So if you've got a bad case, I can't win it for you. I can't guarantee you an outcome. There is a bit of a public perception that in every case there will be a technicality, there'll be a loophole. If only you read the law hard enough, you will eventually find a way to win your case. That's not true. The facts are the facts, and you have to deal with them. That said, whatever position you're in, good or bad, you can always improve it by following these guidelines that I'm about to give you. So even if you're on to fighting a losing battle, you should be able to fight that battle more effectively if you do these things. So first of all, behave professionally. Now, this is, again, another thing that may seem to be basic and obvious. I've had witnesses who've turned up to a tribunal inappropriately dressed. I've had witnesses who sit at the back of the hearing tutting, shaking their heads, rolling their eyes during the other party's evidence. I don't know of a single lawyer who hasn't had at least one witness's mobile phone go off during a hearing. Everyone who comes to a hearing needs to make sure they are behaving in an appropriate and professional manner, because if they don't, that is the first thing that's guaranteed to rub a tribunal up the wrong way. Secondly, concede when you have to. Now, I've dealt with this a little bit already in relation to examination, cross-examination, but I recently had conduct of a hearing where my client was disabled by reason of anxiety and depression. She told her manager about this in a one-to-one meeting, and the manager's own note of the meeting said, Jane, not a real name, has told me that she struggles to complete calls due to her anxiety, and she often has panic attacks and freezes when asked to discuss car insurance. There was an occupational health report and medical records that confirmed that she suffered from these panic attacks, and it took me over 10 minutes of questioning to get this manager to accept that she knew that Jane was disabled at the relevant time, when it was there in black and white in the contemporaneous notes. Don't be a hero. Don't try and win the case on your own. Accept what's obvious and know when you need to accept what the other side's lawyer is saying. Because, as I say, the facts are the facts, and you're not going to get around them by pretending that they aren't. Another basic point, keep a clear and measured tone when you're speaking, and address your answers to the tribunal and make eye contact with them. Be as relaxed and confident as you can. All of this will help endear the tribunal to you. The tribunal are going to be taking notes, so they're going to want to have the time to take those notes, and they can't do that if evidence is coming out at 100 miles an hour. To help you be relaxed and confident, know your evidence. This is, I think, the third time I've said it, but it's because it's important. Read your witness statements, read the relevant documents. Make sure that when you're asked a question, you know the answer and that it's the correct answer. And finally, and this is something that doesn't really relate to tribunal hearings at all, but take notes of your meetings. It just helps enormously when you have a dispute about what's been said in a particular meeting, and the person who conducted that meeting can say, I know exactly what happened because I took a note of it at the time, here it is. Otherwise, what you're generally faced with is the claimant saying one thing, the manager saying the other, and a note just breaks that deadlock in favour of the manager. So if you can get those notes, get them in the tribunal bundle, it's going to make things a whole load easier when it comes to resolving those disputes. Things you shouldn't do. Don't put the boot in. Sarah's already addressed this. It's very tempting when you're given the opportunity to try and make things worse for the claimant, when you're asked a question about whether they were good at their job, to say, oh yeah, and they smelled as well. Don't do it. It doesn't help. It's not relevant. So, and it makes it look as though you've got a motivation to make things worse for the claimant. So it actually makes it look more likely that you have treated them in an unreasonable fashion if you start giving evidence about how much you hate their guts. So if you are dispassionate and accurate, that's a far better position to be in. By all means, say that you're very saddened by the fact that the employment relationship had to come to an end, that you're angry about what they've done if they've committed an act of misconduct. But don't start saying things that aren't relevant, that are just going to make it look like you've got an axe to grind. Don't argue with the lawyers. You're not going to like some of the questions that you're asked. You might be called a liar, you might be called a sexist, you might be called a racist, you might be called a bully. The obligation is on the lawyer to ask questions that put their client's case. And there's no point in coming back to a question like that with, well, how can you possibly say that? Or I think you're bullying me, or I can't be racist because most of my friends are black. Answer the question that you're asked, because ultimately that's what's going to make you look like the open, the honest, the reasonable witness that you want to be. The same applies if the claimant is in person and asking you these questions themselves. They're not going to ask them in the best way possible. They're probably going to be clumsy. try and look like the adult in the room at all times. Similarly, don't avoid the question. Well, I've talked to you about this already, but it really is right up there in terms of things that turn tribunals off when witnesses don't answer the questions that they're asked. Answer the difficult questions as directly as the easy ones. If there's an explanation for why you act in a particular way, give it, but don't start talking about something else or refusing to answer a question because it just isn't convincing at all. Don't be matey. I've seen judges referred to as love, as sweetheart, as mate. I've seen witnesses refer in the tribunal to their lawyers by their first name. I've seen witnesses try to smile and joke with the tribunal about really serious issues of discrimination. Again, just retain that professionalism, and it just avoids the risk of anything going seriously wrong. The risk of trying humour in that way is not worth taking. Finally, don't refer to documents that aren't in the bundle. And this goes right back to what Sarah was saying about making sure you're prepared and making sure that everything is in the bundle that you need. Ideally, all the documents that you need actually should be referred to in your witness statement. But there's nothing worse at the tribunal than being in the middle of someone giving evidence. They're asked a key point by the lawyer for the other side, and they say, oh yeah, actually, we've got a document that proves what I'm saying is correct. Or worse, a document that proves what the claimant's saying is correct. Where is it in the bundle? Well, it's not there because it's never been disclosed. That's the sort of thing that is really going to make a judge suspicious. They're really going to want to examine that in really great detail and work out why it hasn't been disclosed. That obviously doesn't mean that if you're asked a question and the answer is, we've got a document and we haven't disclosed it, then that shouldn't be the answer. Your first obligation is to answer the question and tell the truth. The cure for making sure you're not referring to documents that aren't in the bundle is to make sure they're not missed when you're putting the bundle together, to make sure that you're providing Sarah with everything that she needs at that stage. And that is that. That's the advice I have to give you about making sure that you keep a tribunal on side. The key takeaways, I'd say, are that winning at tribunal is not a game. It's not the case that if you examine the law hard enough, you're going to be able to score the right number of points to win. The way that you win at tribunal is by acting within the law and preparing for the hearing well. It really is that simple. Similarly, getting tribunals on side is very simple. I'd say be professional and be honest. All of the advice I've given you can be summed up in that way. And finally, evidence is king. It's your responsibility to put everything that the tribunal needs in front of them so they can make the right decision. So that brings to an end my section of the talk. I think we're now going to deal with some questions, though I'm conscious we have ever so slightly run over time. I've seen there is at least one question in the Q&A. Sarah, I don't know if you want to manage this part of it and we can respond.
Yeah, that's fine. If anyone does have any other questions, we've got one in the Q&A box here. If anyone else has anything that they want us to cover, just bob it in there now or put it in the chat and we'll do our best to answer those. I've got one, as I say, in this in the Q&A box, but I had one emailed to me yesterday as well, so I'll deal with both of those if that's okay. So the one in the Q&A box is that the claimant in my case was asked to disclose to the respondent in the first instance, and then the respondent was ordered to disclose their documents afterwards. Following the disclosure from the respondent, can the claimant make secondary disclosure as a result of what the respondent is saying? It can happen that disclosure happens in stages like that, depending on what the tribunal have ordered. The expectation would initially be that everything is disclosed by the deadline that you're given, but disclosure is an ongoing duty. So if there are other documents that come to light for whatever reason, you do still have a duty to disclose those. It's obviously not quite right that you get an extra chance to find other documents when you're told that something else is relevant. But ultimately, the key thing to remember is that the tribunal will want to see every document that needs to be referred to. They want to see all of that evidence. So if it's relevant, it's relevant. And as long as you're getting it in good time, then yes, they could potentially come back with more. And for the most part, you're normally better to accept that, but it would very much depend on the specific case. And I'd check with anyone that's representing you on how to deal with that.
I would just add to that. All of that's absolutely right. You want to try and avoid this sort of disclosure ping pong. And the way to do that is to make sure that actually you're really clear at the outset what the issues are, because you're disclosing documents that are relevant to the issues. So this should never be necessary if the issues are clear at the outset. It may be that as a result of the respondent disclosing some documents, there is a new issue that's arisen that the claimant needs to deal with, and that's why there's more disclosure that then needs to come through. But the way that you make sure that doesn't happen is making sure you know at the start what the disagreements are between the parties, because then it only needs to happen once.
So the only other question we had, it came through on an email, and it was, when carrying out disciplinary proceedings, would judges expect employers to take into consideration the pressures of the pandemic, for example, working from home for long periods of time when this would not be usual for the individual? Ultimately, what the tribunal take into consideration really depends on what claim is being brought. So when a claim is being pursued, there are specific legal questions that the tribunal have to address to make a decision. And generally speaking, I guess without knowing how the disciplinary fits into a claim, it's difficult to say. But if you're talking about something like an unfair dismissal claim because someone's been dismissed off the back of a disciplinary, or you're talking about a discrimination claim because the disciplinary is alleged to be in some way discriminatory, then you would generally be expected to take into account all the circumstances at the time that disciplinary takes place, all the relevant circumstances. So if for some reason the pressures of the pandemic or the home working is a key point related to the disciplinary, the mitigation, the reason for the actions, then yeah, you would need to take that into consideration. But ultimately, it depends on the type of claim.
This actually is something that Sarah said at the outset. Neither of us have really sought to deal with the merits of different types of claim. That's not really what this is about. But when considering certainly unfair dismissal, the obligation on an employer is to act reasonably in all the circumstances. And the pandemic is one of those circumstances. So the tribunal are going to be looking at whether, taking into account the pandemic and policies and the behaviour of the employee, if it's a misconduct case, for example, then was that behaviour within the reasonable range of responses? Was the action taken by the employer within the range of reasonable responses that could have been taken? So the pandemic will be taken into consideration by the tribunal because it's one of the surrounding circumstances. So generally speaking, yes, if it's a material factor in how someone has behaved, it should be taken into account. Now, that's not to say that because someone's behaving differently because there's a pandemic on, that they can't be dismissed. You just need to make sure that you're acting reasonably, taking it into account, and referring to it when you give your reasons for dismissing that person. For example, let's say that in this case, it's a misconduct case, that someone has been persistently not being on their Zoom or whatever at the time they're supposed to be. They're persistently late. And you've been through all the normal processes, you've reminded them, you've issued them with a warning, they're still not doing it. When you give your reasons for dismissing them, you'd have to say, well, we've taken into account that the pandemic's making things more difficult for everyone. As a result, we've given them more leeway than we normally would. However, we still think this is unacceptable. They've still had a final written warning. They still haven't been able to do anything. And so therefore, we're dismissing them. That is a potentially reasonable way of dealing with things.
Great. Well, that's all the questions we've had sent through. So thank you everyone for listening. I hope you found it useful, interesting, and can take something away from it. I hope you don't ever have to deal with a tribunal claim, but if you do, obviously this will help. We're here, and by all means, just get in touch if you need anything. So thank you very much, Dan, for your time today.
Thank you very much for having me, and thank you everyone for listening.
Pleasure. Okay, thanks everyone. Bye.